have gathered here for the webinar session. So first of all, a warm good evening to one and all present here. Amidst all the busy schedules, we all are gathered here for an interesting session on a very interesting topic. So we know that India is currently in an election phase, and just like any election time, there are many discussions and debates on various topics that are happening in the society, and in which one of the most interesting topic is about the electoral bonds, and recently there was a Supreme Court judgment relating to it. And today we are gathered here for a critical analysis of the electoral bond judgment. And so without much delay, let's start the session with a welcome speech. I invite Sri Lakshmi to deliver the welcome speech. Over to you, Sri Lakshmi.
Am I audible?
Yes, you are.
Okay, first of all, I'm sorry, my camera is not working properly. So, good evening, everyone. On behalf of LJRF Group for Constitutional Literacy, it is my pleasure to extend a warm welcome to all of you to a webinar on electoral boards. Electoral boards have become a topic of significant interest and discussion in recent times, given the impact on political funding and transparency in electoral processes. Today, we have gathered here to delve deeper into this important subject and gain a better understanding of its nuances. We are honored to have esteemed speakers with us today. First, we have Mr. Lawwellman, an associate professor of law at Government Law College, Kozhikode. He obtained his PhD in IPR from National Law School, Bangalore. He completed his master's in law from School of Legal Studies, Cochin University, with specialization in intellectual property rights. He worked as research associate in Center for Intellectual Property Rights in National Law School, Bangalore. Practiced as advocate in courts of law in Kerala for 4 years, worked as manager in Federal Bank and Bank of Baroda in Kochi and Mumbai for 5 years. Dr. Lawwellman has been a resource person for various IPR and other programs within and outside Kerala. I welcome you, sir. Secondly, we have Mr. Safi Mohan, an associate professor at Government Law College, Trivandrum. Sir is a postgraduate in law with a teaching experience of 14 years. He has legal expertise in the field of constitution, IPC, CRPC, professional ethics, judicial process, and legal education. He was a former member of Academic Council, Kerala University from 2016 to 21. He is the author of the book Gandhi and His Philosophy of Secularism and has co-authored a complete reference book for law examinations, judicial and legal services exams 2016. The assistant professor is also the founder of Law and Justice Research Foundation and State Secretary of C.K. Chandrapan Center for Social Justice. So I would also like to extend a warm welcome to all our participants joining us from different corners of the globe. Your presence enriches our discussions and contributes to the diversity of perspectives we will explore today. So as we embark on this journey of exploration learning, I encourage everyone to actively participate, ask questions, and engage in discussions. Let us make the most of this opportunity to deepen our understanding of electoral bonds. So once again, welcome to a webinar on electoral bonds. I hope you find this section enlightening and thought-provoking. Thank you.
So I have titled my presentation as Understanding Electoral Bond Judgment. Understanding Electoral Bond Judgment. The judgment is Association for Democratic Reforms, which is a well-known NGO which has come up with very many other PILs earlier, especially relating to electoral reforms, or rather which gave impetus to even Supreme Court and the legal system to make electoral system more transparent. So many of our participants here would know there are very many cases which were initiated by this association. And in fact, there are other 2 petitions also which were heard together with this by the 5-judge bench, which delivered the judgment on 14th of February 2024. So the case is Association for Democratic Reform and another versus Union of India and others. And this is otherwise known as electoral bond judgment. Now, what is an electoral bond? let's go to a little bit of history, which will put things in perspective. Late Arun Jaitley, a former Union Finance Minister, when presenting the 2017-18 Union Budget, mentioned that the country has not yet evolved because it was almost 70 years since India had acquired independence and it had become a republic. It does not have a transparent system, a method of funding political parties, which is vital to the system of free and fair election. A very good statement to make in a democratic country, that too in a largest democratic country. A very good statement on the face of it, apparently. And he proposed, late Arun Jaitley proposed electoral bond scheme, which was designed to cleanse the system of political funding. The political funding, admittedly, is not that transparent, and there are very many issues with regard to that. Black money issues are there, opaque nature is a problem with regard to that. And this system was said to be a panacea for all these, and it is meant to cleanse the system of political funding. This is how it started off. Now we have before we go further into this, this is a sample which I could gather from Google Images of electoral bond. This is issued by State Bank of India. Electoral bond, the system as it existed for some time, which does not exist now after the judgment of the Supreme Court, but as it existed for some time, this is an electoral bond. This looked like this. This is just a sample of that. And it could be issued by any scheduled bank, at a stipulated time, as time stipulated by Government of India, mainly 4 times in a year. In every quarter, 10 days as stipulated by the Government of India. And there could be additional days stipulated by government when it comes to election season, etc. That's how it went off, or rather it was supposed to be. Now, if you look at that, I invite the attention of all the participants to this, because this is where we start off with. Date of issue is there, 10th April 2018. This is just a sample which will give us an understanding so that our discussion will be fruitful, and this will be the foundation for that. And its validity is for 15 days from the date of issue. So it is valid for 15 days from 10th of April 2018. And this instrument's value is 10,000 rupees. It could be 4,000, it could be 10,000, 1 lakh, 10 lakh, 1 crore. This is how its denominations could be. And this is how it's said. And I wanted to emphasize on one thing. There are certain things which are put in Hindi, which I'm finding difficult to discuss, but there are certain things in English as well. And it is written there under in a paragraph in 405 lines. It starts like this: for value received. For value received. Let us read that importantly. I've got that in bigger size because I wanted all the participants to say this. I thought this is important. It goes like this: for value received. So this scheduled bank, which is issuing an electoral bond, has received a value. It looks like a promissory note under Negotiable Instrument Act 1881, and it says like this. Just have a look at this. Please read this and apply your mind. Let us do that together. For value received, the bank hereby promises, the scheduled bank hereby promises to pay on demand. This looks like Section 4 of a Negotiable Instrument Act, right? That is about a DPN, promissory note. The bank hereby promises to pay on demand to the eligible payee. Who is the eligible payee? We do not know. We do not know. To the eligible payee, which is holding this instrument. We do not know who is holding this, and we do not know who is the eligible payee. Upon surrender of the original instrument in the designated account, the designated account of the eligible political party. So payee is not known, It is a political party, and that is mentioned as eligible political party, and we do not know who is the payee and which is the political party with the bank. The sum representing the value of this instrument, and in this example it is for 1,000 rupees. In fact, the amount involved is much bigger, and the amount perhaps is, as we know now, it is mind-boggling amount. Here it is 1,000 rupees, rupees 1,000, in accordance with a scheme called Electoral Bond Scheme 2018. So this is a scheme of 2018, and this is known as Electoral Bond Scheme 2018. It is notified by the central government, and notification number is 20, dated to 2nd January 2018. And it says, on payment of the said amount, the liability of the bank hereunder shall stand fully extinguished. The liability will extinguish. What is notable here is there is no specificity as to who are the parties involved in this. Somebody is paying some amount through some bank to somebody. Who is paying? We do not know. Who is the payee? We do not know. But it looks like a demand promissory note, and there is an uncertainty about all this. This instrument is opaque. Please go back to Donegal versus Stevenson. That is where the word opaque was used and heard many times by me. Many of us must have the same experience. Opaque bottle, not transparent. Who is paying it? We do not know. Who is getting it? We do not know. The amount, of course, we do know. But let's go further into this. Let us dig further into it, as Sri Lakshmi was saying. What is an electoral bond? Electoral bond is like a promissory note. It is like a promissory note. We just had a walk through that. We just read it, and it is a bearer instrument. We have to have an understanding about a bearer instrument and an order instrument. We do not have enough time for that, but bearer instrument is an instrument which will entitle the bearer, the person who is holding it, entitled for the value of it. If a person person belonging to a political party is holding an instrument of 1,000 crore or 100 crore electoral bond, if I am holding this, I am the holder of it, I am the bearer of it, and I am entitled for the payment. I'm entitled for the payment. That's how it goes. Unlike a promissory note, though it looks like a promissory note, which contains the details of the payer and the payee, who pays it and who gets amount, both are very clear. That clarity is the hallmark of Section 4 of Negotiable Instrument Act. But here, it is conspicuously missing. An electoral bond has no information on the parties in the transaction at all. I emphasize that. Providing complete anonymity and confidentiality to the parties. Providing complete anonymity and complete confidentiality to the parties. Of course, it protects privacy in a way. But what is it supposed to be? It is supposed to be a transparent system to do away with the cleanser system, do away with black money and things like that, and to bring in a lot of fairness in a public activity, a constitutional mission it was supposed to be. Who can buy it? There's a list of people, anybody can buy it. An individual citizen, a Hindu undivided family, an Indian only animal called Hindu undivided family, a company, a firm, an association of persons, or a body of individuals, whether incorporated or not. Even a partnership can do it. Other persons or agencies. Anybody can do it. Anybody can pay to a political party. It's supposed to cleanse the system. And an individual citizen can buy the bond either singly or jointly with others. This is the system. Let's move on. Who can encash the electoral bond and how? A party should be registered. The political party can only encash this, because this is an electoral bond payable to a political party. A party should be registered under Section 29A of the Representation of People's Act, RP Act. The party should have secured at least 1% of the votes polled in the last general election to the Lok Sabha or State Assembly. So in a way, any political party can be at the receiving end of this without being disclosed their identity. Who is playing it? We do not know. Who is getting it? We do not know. Only through a bank account. That's great. Only through a bank account, which is, if it should be an authorized bank, a bank which is authorized by the central government. Only through such a bank this payment can be received, and it was it was there for a while. As we know, it is no more now. State Bank of India was the only authorized bank, and that was the reason why State Bank of India and its officials were in some dilemma, in some problem, some contempt, contempt apprehensions, etc. So it can be encashed only through an authorized bank, and at that time, for that particular time, where the electoral bond lived, State Bank of India was the only authorized bank. The bond will be available in the denomination of 1,000, 10,000, 1 lakh, 10 lakhs, and 1 crore. And we do know how many crores did turn in electoral bonds. Okay, then when will the bonds be issued? What is its validity? 10 days each in the month of January, April, July, and October every year, as specified by the central government. So once in a quarter for 10 days. 10 days. As if you are aware of a sovereign gold bond scheme, State Bank of Reserve Bank of India will notify it, and for some 1 week or so, it will be available for us to purchase. It is something like this. So 10 days in every quarter. The government can also, the central government can also specify an additional 30 days for the purchase of the bond in the year of the general election to the Lok Sabha. So there is additional possibilities available. Okay, so it is tailor-made for the political parties. The bond will be valid for 15 days. Once issued, it will be valid only for 15 days, and political parties should encash it in 15 days of time. So if it is 10th of April, then 25th of the April will be its 15 days will be its lifetime, and it should be encashed within that. And it should be done through the authorized bank. Here it was State Bank of India. The amount of bonds not encashed within 15 days validity period will be deposited by the authorized bank, State Bank of India, to the Prime Minister's Relief Fund. A great mission again. Prime Minister's Relief Fund. So this is how it goes. This is how the scheme scheme existed. And there is additional, there is a real icing on the cake for the contributors. The contribution made by the individual or company or any other entity, as we understood now, through an electoral bond will be exempt from income tax as per section 80 GGC and 80 GGB of the IT Act. Again, there is what you call income tax exemption. There is another attraction, enticement. This is how it goes. Now, this is how the application for the electoral bond looks like, or looked like, I would say. Application form for the electoral bond. Here should be mentioned name of the issuing bank, the scheduled bank. Any scheduled bank is authorized for that. Name of the branch, date, all those are there. And if you come down, name applicant status is to be mentioned. Individual, HUF, company, firm, charitable trust, others, etc., etc. Applicant's details in block letters, that should be mentioned to the bank which is issuing it. First or sole applicant name in full, that should be there. Details of identity, and there should be no KYC for that. Know your customer details given, passport, Aadhaar, voter ID, etc. Second applicant, and all the details should be there. So the details will be disclosed to the bank. Bank will know who is paying to whom. Perhaps not to whom may not be known, but who is making the payment will be known to the bank. But an ordinary citizen like you and me will not have an opportunity to know this. Okay, electoral bond scheme. Let us understand it further legally. How does it work? The Finance Act 2016 amended FCRC 2010, Foreign Contribution Regulation Act 2010, to permit foreign companies who have a majority share in Indian companies to donate to political parties. So this particular amendment made a change and permitted contribution by foreign companies to political parties. Foreign companies which has got share in Indian companies. Previously, earlier to this, Foreign companies were prohibited from donating to political parties under FCRA, the act which we talked about, and also under FEMA, Foreign Exchange Management Act 1999. That was the position, and that was changed. That was just starting. Let's understand further legally. The Finance Act 2017, which came in the consecutive year, brought about four major amendments, or amendments to four major laws. Representation of People's Act, obviously it should be there because electoral bond is many things to do with RP Act 1951, the Reserve Bank of India Act 1934, the Income Tax Act 1961, and the Companies Act 2013. These were the four enactments in addition to the 2016 amendment. These were the four other laws and amendments carried out to bring about electoral bond system of 2018. And what was the amendment to RPA amendment, RPA Act? The proviso to section 29C of RPA, Representation of People's Act, to section 29C. And from that, there was a proviso added exempting. Proviso is usually for the purpose of exempting something. Exempting political parties from publishing contributions received through electoral bonds and contribution reports. Political parties were under an obligation to disclose its the contribution received by it, and Representation of People's Act was changed for that, and electoral bond contributions were not to be disclosed. What a transparency. Okay, these reports before that, earlier to that, disclosed contributions received to parties in excess of 20,000 rupees from companies and individuals. Let's move on. Let us understand what happened in RBI Act. RBI Act was also amended, as I said, amended section 31 of the RBI Act 1934. This permitted the union government to authorize any scheduled bank to issue electoral bonds. And there was vehement objection to this by RBI, and that was overlooked or overruled by the central government. We are not going into that because time is at. Sir is particular about the time schedule. Okay, so any scheduled bank need not to be even a public sector bank. Any scheduled bank could include issue electoral bond. So it was so much facilitative. But in spite of the Reserve Bank of India Act, its monopolization of this activity, or these kinds of bearer bond instrument issuance to RBI, etc. All these were overlooked. Going further, Income Tax Act was amended section 13A of the Income Tax Act, exempting political parties from keeping a detailed record of the contribution received through electoral bonds. So again, what it says is it need not report it under Representation of People's Act, and they need not, even in their own books, even if it is inspected, the identity of the people involved will not be known. What a system, what a transparency. Okay, moving further, Companies Act, that was also amended because major contributors will not be individual citizens, but it will be companies, because we know what happens and how it happens. So amended section 182 of the Companies Act 2013, which came after 1956 Act, which removed the upper limit on how much a company could donate to a political party. Before this amendment in 2017, there was an upper limit which a company can contribute or donate to a political party. It was 7.5% of the 3 years of company's net profits after tax, all those. So previously companies could only donate up to 7.5%. Now even that cap is taken off. Just think of all this together, 4 or 5 amendments. Foreigners can do it. Income tax exempted. Income tax disclosure is not there. RP disclosure is not there. Any company can, without any cap, can do it. And RBI does not have the monopoly, and RBI does not have a control as a central bank. Any scheduled bank can issue this. Yeah, liberalize how much. So the issues before the court, issues before the Supreme Court. This is as it is framed by Justice Chandrachud as it is available in his judgment. Whether unlimited corporate funding to political parties, as envisaged by the amendment to Section 182(1) of the Companies Act, infringes the principle of free and fair elections and violates Article 14 of the Constitution. Article 14 of the Constitution. Shall we read this issue once again so that we will really do understand this? Whether the unlimited corporate funding, as we understand from the amendments and the scheme of electoral bond, as we understood now, whether unlimited corporate funding to political parties, as envisaged by the amendment to Section 182(1) of the Companies Act, whether it infringes the principle of free and fair elections, and does it violate Article 14 of the Constitution, whether it is arbitrary, is it bringing in transparency, or is it making it more opaque and otherwise. The second issue, there were only two issues. The second issue, whether the non-disclosure of information on voluntary contribution to political parties under the electoral bond scheme, and amendment to Section 29C of Representation of People's Act, Section 182(3) of Companies Act, and Section 13A(b) of the IT Act are violative of right to information of citizens under Article 19(1)(a) of the Constitution. Let us understand this question also. Because in a way, election and casting a vote is an expression. It's an expression of people like you and me. It is a decision and it is an expression, and it is well within Article 19(1)(a), which speaks about freedom of speech and expression. And a necessary corollary of Article 19(1)(a), your right to freedom of speech and expression, is a right to form opinion based on proper information. And Supreme Court has held in many cases, if you read the judgment in full, there is a proper or rather, I request and I strongly suggest you read the judgment, especially of Justice Chandrachud. You understand how to write a judgment, how beautifully he has written, how systematically he has written. He has got a content page, he has got systematic points for that, very systematic. Even otherwise he does like that, and even in this he is doing the same. So a systematic way of writing judgment. Of course, it is a little ultra virus of the discussion, but I think it is appropriate for me to state that. Okay, now, so Article 19(1)(a) as a fundamental right has within its ambit a right to get information also. Right to Information Act has its birth in some of the Supreme Court judgments under Article 19(1)(a), and some of these judgments were inspired or rather initiated by the same petitioner, Association for Democratic Reforms. There are certain decisions, and those decisions are listed out and in a particular chronological way by Justice Chandrachud beautifully. So Article 19(1)(a) has within its fold the right to get information also. So who gets money, which political party gets money, from whom, how much and how? Are these important information? The court goes into this question. Because our decision, and there is an intimate connection, Supreme Court says and Supreme Court establishes through the judgment. If you go through the judgment, Supreme Court unanimously decides this, but there is a different judgment, which of course it comes along with the main judgment. There are 4 judges along with the Chief Justice of India, and there is another judgment that also contributes the same thing, ultimately comes to the same decision that electoral bond system should be scrapped. But if you go to this, the Supreme Court goes to the question, is knowing political party and its funding. There is a lot of connection between funding and politics. If you have watched the movie Lucifer, I think that be contextual. Lucifer, a Malayalam movie which was a big hit a few years back, and that really brings in the relation between politics and the need for funding. And even I came to came to be aware of need for funding and the political connection. Of course, I knew to some extent, but that film really opened my mind or brought those things to limelight. Or rather, that film really made my reading of this judgment better. So even Justice Chandrachud brings in that and he establishes it. And he says that a knowing political party would definitely has its corollary, a major corollary, knowing its funding, the nature of funding, the person of funding, and how much funded, and all those kinds of things are knowing a political party is part of knowing a political party. And a person who is participating by way of voting in this political process, is supposed to know these details. This is what the court says. But as we understood through these 405 amendments, what the government has done, what the legislature has done, is made the process more opaque and denied the opportunity, like people like you and me. This is the sum and substance of the judgment. People like you and me to know the whereabouts of this funding and things like that, which are very much important as far as this electoral process is concerned. So our decision making will not be an informed decision. That's the distilled essence of what Supreme Court has said. And if we are not able to get information on these kinds of things, it is violative of a necessary corollary, necessary principle enshrined under Article 19(1)(a) of the Constitution, that is right to information. So we do not have right to information, right to major information while exercising a political right, in participating in a political process. And that violates our fundamental right under Article 19(1)(a). That's how the Supreme Court says. So I've got the details of the petitioners here. Petitioners include Association for Democratic Reform, Common Cause, and Communist Party of India, Marxist, CPIM. And major respondents: Union of India, Election Commission of India, and of course SBI was also in the mudslinging. And now the judges, the judgment was delivered on 15th of February 2024. Chief Justice of India, Dr. D.Y. Chandrachud, DYC, was the person who delivered the major judgment. There was another concurring judgment also. Other judges were B.R. Gavai, J.B. Pardiwala, Justice Manoj Mishra, Justice Sanjeev Khanna. It doesn't end there. We'll have to have some more understanding about this. Of course, I'll keep my discussion within 25 minutes, I hope. The Supreme Court unanimously struck down the 2018 electoral bond scheme. The bench held the deletion of a provision in the Companies Act permitting unlimited corporate contribution to political parties, as it was considered to be arbitrary and violative of Article 14 of the Constitution. If we understand Article 14 has within its fold not only equality before law and equal protection of laws, but over a period of time, the Supreme Court, through very many judgments, held that even rule against arbitrariness, rule in favor of natural justice, etc., are also part of Article 14. Equality within its fold, all these principles also. Some of the cases which judgments and the Supreme Court has discussed, and we all would know, are judgments like E.P. Royappa and very many other judgments, wherein the Supreme Court has said executive action should not be arbitrary. If the executive action is arbitrary, then it will violate Article 14 of the Constitution. But as we understand, here it is legislative action. But later on, through very many judgments, some of the judgments I would mention here is Josephine versus Union of India, the adultery case, again from Kerala, wherein Justice D.Y. Chandrachud himself, writing his judgment, striking down Section 497 of Indian Penal Code, has said that not only executive action are within the clutches of Article 14 under the rule against arbitrariness, but also legislative actions can be, can have problems with rule against arbitrariness under Article 14. So even legislative action can be declared as unconstitutional as against Article 14, and thereby violates Article 14 of the Constitution, right to equality of the Constitution. So that is also established over a period of time, and those cases are also very properly systematically discussed by Justice Chandrachud in this judgment. So it says that unlimited corporate contributions, even including even foreign company contributions, violates rule against arbitrariness, and this legislative action is arbitrary and it is violative of Article 14 of the Constitution. And when it comes to Article 19(1)(a), as I've already said, Article 19(1)(a) has within its fold, through very many judgments, including the judgments of Association for Democratic Reforms, the petitioner herein also, the Supreme Court has said in very many words that right to information is part of Article 19(1)(a) of the Constitution, and that is being violated when the citizens like you and me are not given an opportunity to understand the politics and the money behind politics. The subheading in the judgment is the relation between political parties and money. That's how it goes. So it is. We all know that, and the Supreme Court has taken it in the true perspective and brought that in. And if the sources of money is not known, payment amount is not known, and the people are not known, the people who are getting it is not known. If the system contemplated was such a system, and if these things are not known, then it violates your right to information, because unless you get a proper information, you won't have a proper decision as to how your electoral political right is to be exercised. So this expression of ours will not be a proper expression. To make our expression proper, we need to have access to, we should be able to lay our hands on proper information, and this scheme system, which is brought forth through these amendments or 4 or 5 enactments, is supposed to be opaque and making things out of sight of citizens. So it is not enabling, rather it is disabling, and it is not transparent, but it is opaque. And that's the reason why all the judges unanimously declared on 15th of February 2024 that this system should be scrapped and these amendments should be declared as unconstitutional. Supreme Court did not stop there. It went a little further. Let's just understand what happened. We read that in the newspapers, in channels, etc. But let's just understand that. So I'll state that as well and wrap up the discussion from my side. The Supreme Court also directed that the sale of electoral bonds be stopped with immediate effect, forthwith. SBI, the only authorized bank through which electoral bond could have been encashed, was directed to submit details of electoral bonds purchased from 12th April 2019 till date of the judgment. And there is a spelling mistake there. Please, excuse me for that. Till the date of judgment to Election Commission of India. So SBI was supposed to. We know what happened there, and Supreme Court had to come out with a stick for the SBI to make it transparent. This will include details of the purchaser as well as political parties that the bonds were given to. And further, the court ordered the Election Commission of India to publish the information shared by State Bank of India, the authorized bank through which it was encashed, on its official website within 1 week from the receipt of the information. So this is how it goes, and I think this is the time for me to stop this. As per our understanding, Safi sir will be speaking about the judgments which prompted the Supreme Court to reach this decision and the matters related to that. So I've just set the stage, and Safi sir will enact much more on electoral bond case. So drama is to be continued, and you have a better actor to do that. So, Fisa, that's it from my side. Thank you so much for the opportunity.